Hello everyone, today I will be doing my case on Nova Scotia v. Walsh that occurred in 2002. Before we get into the facts of the case, I would like to define 3 of the sections that will be discussed throughout the video. The first one I would like to define is Section 2G of the Matrimonial Property Act. I will also be referring to it as the MPA throughout this video. Section 2G states a spouse means either of a man and a woman who 1. Are married to each other, 2. Are married to each other by a marriage that is voidable and has not been annulled by a declaration of nullity, or 3. Have gone through a form of marriage with each other in good faith that is void and are cohabiting or have cohabited within the preceding year. And for the purposes for an application under this act, it includes a widow or a widower. The next one is Section 15.1 of the Charter under Equality Rights. Section 15.1 states every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. The last one I would like to discuss is Section 1 of the Charter of Rights and Freedoms in Canada. Section 1 guarantees the rights and freedoms set out in it subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. And now we will be discussing the facts of the case. To begin, for about 10 years, Suzanne Walsh and Wayne Bona cohabited as a common law couple. When the couple split in 1995, their 2 sons from their marriage remained living with their mother. Following the breakup, Walsh requested spousal and child support. She also challenged the charter to the MPA's definition of spouse, which is restricted to married couples. In the event of a divorce or the passing of one spouse, the MPA specifies how marital assets will be divided. Additionally, it creates temporary remedies like sole custody of the family home. Okay, now we will be moving on to the issue of the case. The issue in this case is whether making a choice matters and whether unmarried persons are prevented from taking advantage of the benefits of the MPA in an unconstitutional way. Walsh also claimed that the similarities between common law couples and married couples are so similar that the exclusion of common law couples from the definition violates her human dignity. Next, we will be doing the court and what they were faced with. The court was faced with 2 questions. The first one was, did the definition of spouse discriminate against heterosexual unmarried cohabitants in violation of the Charter of Rights and Freedoms Section 15.1 equality provisions? If the answer to that question was yes, the court's task was to determine if the discrimination could be preserved under Section 1 of the Charter. Writing for himself and 6 other justices, Judge Bastarache found that the dignity of unmarried persons living in common law relationships was not affected by their exclusion from the operation of the MPA. Bastarache determined that there was no discrimination under Section 15.1 by using the 3-part test established by the SCC in Law v. Canada, which was the Minister of Employment and Immigration case. This left the court to decide whether the differential treatment was discriminatory or not. Bastarache framed the question as whether a reasonable heterosexual unmarried cohabiting person, taking into account all of the relevant contextual factors, would find the MPA's failure to include him or her in its ambit has the effect of demeaning his or her dignity. The majority boiled the answer to this question down to one main element, which was choice, and the choice whether or not to marry. On December 19, 2002, the Supreme Court of Canada issued a majority ruling in Nova Scotia v. Walsh, where they held that the Nova Scotia MPA's exclusion of common law couples from the definition of spouse is not discriminatory, and if it is, then it is saved by Section 1 of the Charter. My opinion on this case is that I do agree with the majority's ruling. I feel like if the court would have agreed with Walsh's claims that it is discriminatory and that she deserves the same benefits that married couples receive, I feel like that just completely disregards the meaning of having a marriage, because then no one will be getting married. Marrying someone means that they are making a lifelong commitment to one another, and this is why they should be entitled to all the benefits that they receive, and even the ones that they receive long after the marriage is over. Although this case was after their marriage ended, it seemed to me that Walsh wanted to take the easy way and enjoy all of the benefits and advantages that come with being married without actually being married. This case is socially relevant and important to me because the court put their foot down and said no to common law couples who expected to have the same benefits as married couples. I'm happy that the case worked out the way it did because it proved the true value and importance of a marriage. I wanted to thank you guys for watching, and I hope you enjoyed this video.